Hi, everybody. I'd like to welcome you to the first in-house event at the ASJA Educational Foundation. This is the first in what will be an ongoing series of hybrid events combining a real-life meeting here with an online streaming webcast held here in our own home. We've done these events before, but never here under our own roof. There are more people watching and participating than there are here in the room, so I hope you'll bear with us as we try to make this experience great for everyone. I'd like to welcome the online audience especially. This is our first use of the webcasting equipment, but we hope you won't be able to tell. We will be taking the questions from the online audience as well as those from the people in the room here. Online folks, please do not submit your questions right in the chat window. We'll post a link periodically where you can submit your questions. They will come right to me, and when we get to the question period, I will relay them to Chris. And I hope you're all saving the date for the 41st Annual ASJA Writers Conference. I have to get a plug in there. Next April, there will be 84 sessions over 3 days, all aimed at helping freelance writers have more successful careers. Everybody can participate. You can support the ASJA Educational Foundation by joining our mailing list, visiting us online, downloading recordings of our previous and future sessions. You can find it all at asja.org. We hope you'll take advantage of our programming, and please submit ideas for future sessions. We're always open to suggestions. We want to create a full calendar. Our first visitor is Chris Kenneally. We very much appreciate his time and help and guidance in this endeavor. And here's his introduction. Christopher Kenneally is the Director of Author Relations at the Copyright Clearance Center. He's responsible for organizing and hosting programs that address the business needs of authors and publishers of all backgrounds and sizes. He is, among other activities, he is the host and producer of CCC's weekly podcast series, Beyond the Book, which I can highly recommend. He occasionally contributes opinion columns on media and publishing to the Boston Business Journal and Publishers Weekly. And one of the great podcasts is every Friday he will talk to Publishers Weekly about what's coming up in the following week's edition, so you can get a heads up by listening to that podcast and get a little bit of the behind-the-scenes stuff. As a freelance journalist, Chris reported over many years on education, business, travel, culture, and technology for the New York Times, Boston Globe, Los Angeles Times, and the Independent of London, among other publications. He also reported for WBUR-FM, National Public Radio, and WGBH-TV in Boston. He is the author of Massachusetts 101, A History of the State from Redcoats to Red Sox. I am thrilled to welcome Christopher Kenneally to the ASJA Educational Foundation.
Well, thank you indeed, Alex, and thanks to everyone who's here in person. I never thought I would be live from Times Square, but here I am this evening to do that, which explains to the people who aren't here, if they hear an occasional siren, it's not because they're trying to raid the building or anything like that. It just happens to be Times Square on an average evening. I appreciate the very warm introduction that Alex gave me. I want to take note of the fact that we have some people here today from a local high school, and I think that's interesting to ponder that we've got a new generation of writers coming to join the ASJA, and I just try to imagine what they said to their parents before they went out this evening. You know, Dad said, "Well, where are you going tonight?" And they said, "Well, we're going to a copyright webinar." And Dad said, "Yeah, right." It's rather like somebody from Publishers Weekly, Alex was mentioning our podcast with them, and they're at Frankfurt Book Fair this week. And he was having some problems, he said, with his internet connection. And this was last night at about 7 o'clock at night. And I thought, no, I think you're in a beer hall somewhere. And that's why you can't do this. So really want to thank the people who are here and, again, the people who are online. The title of the program is The Challenges of Copyright in the Internet Age. And I want to make a point before getting going here that in the Internet age, we are all copyright holders. We are all content creators. In the past, you could be an author, an occasional copyright holder. You could be in the publishing business and have copyrights of your own. But today, everyone carries around some kind of a cell phone with a camera at least, video quite possibly. Perhaps you've got Facebook on your phone, or you have your blog. All those activities, whether you're, a professional author or in the publishing business, all those activities of creating content and sharing it, publishing it, create a copyright of its own. I'll go into what that really means, but I think it's a point to underscore. Everybody in this room, published or unpublished, has copyright in all the images that they take on their camera, all the words they write in a blog or in an email. All those things themselves are copyrighted. Probably for the sake of everybody online, I'll just mention if you have any questions for me following the program, certainly as Alex mentioned, we'll take questions at the end, but if you have questions for me tomorrow or next week, I welcome your emails. It's Chris K, very simple enough, chrisk@copyright.com. I'll just give you a brief idea of what we'll be talking about today. As I mentioned, I'd like to go through the slides and give you the background on a variety of aspects of copyright, and then we'll take the questions following that. We'll talk about the basics of copyright law, what is and what is not protected by copyright. Fair use, a loaded term, and we'll ask what it is and find out a bit about how it works. We'll look at when copyright permission is required to use materials, and we'll talk about how to obtain that permission as well. I find as I do these programs for both authors and publishers, a surprising interest in the subject. To me, it's rather like dairy farmers coming to find out about how milk comes from cows. It's an essential aspect of the business of writing and publishing to grasp some of the basic fundamentals of copyright. So I'm happy to help you with that, and I'm going to bet that some misconception may be cleared up for you in this program. Let me tell you briefly about Copyright Clearance Center. We are online at copyright.com. I've already been asked today about our relationship with the Copyright Office, and let me straighten that right out. We are a private, nonprofit company. The Copyright Office is online at copyright.gov, and they are, of course, a federal government agency. Copyright Clearance Center was founded in 1978. We are a not-for-profit. We are based just outside of Boston, Massachusetts, a town called Danvers. Altogether, we manage probably now, I would say that's number is like 500 million rights for authors, publishers, and agents here in the U.S. and around the world. We are indeed now a global company. We have a subsidiary based in Amsterdam called Rights Direct. And I think that also reflects the way that the world of publishing has become every bit a global industry, because every time something is put online, it is immediately available, not just in this country, but around the world. And we like to think that as a global rights broker for all of the world's most valuable information, we help simplify the process. I know that that's probably sounds like an easy statement to say. I'm going to try to tell you a bit more about that later. But really, as confusing as it seems sometimes about copyright, there are some really basic points. If you hold on to those, you'll be fine. As Alex mentioned, I was a journalist for many years and reported a great deal from Northern Ireland in the time of the Troubles. And we used to say that if you're confused, you're beginning to understand the problem. So if you feel a bit confused about copyright, don't worry too much about that. I think you're in reasonably good hands today. I should just clarify too something about the relationship that ASJA has with Copyright Clearance Center. Bit indirect, but worth bringing up. ASJA is a member of the Authors Coalition of America, and the Authors Coalition of America works with Copyright Clearance Center and another organization, a global one, called the International Federation of Reproduction Rights Organizations. We'll be talking more about these so-called collective management organizations. You're probably more familiar with ASCAP or BMI, but RROs are a type of collective management organization specifically for content in published form, print, and images as well. So what we do with the Authors Coalition and with ASJA as a beneficiary is to help repatriate some of the licensing fees that are collected outside the United States back to the U.S. And finally, together, which is what we're doing here, CCC can offer a variety of educational programs around copyright, and all of that can be found on our page at copyright.com/education. So let's get started then with a point I want to make about why we're all here, why we're doing this. There's a great deal of talk about the so-called creative economy. And I looked into it. Richard Florida, who's a professor at the University of Toronto, actually, I believe, coined the phrase the creative class. And he says this is a relatively new class, that some 38 million Americans, or 30% of all employed people in this country, belong to this new class. It's a catch-all term that can include people in science and engineering, architecture and design, education, arts, music, and entertainment, all of whose economic function is to create new ideas, to innovate, to invent technologies. And I think everybody here involved in publishing is part of this creative class and driving that creative economy. But it all goes back to a day when there wasn't much technology to speak of. Copyright is enshrined in the U.S. Constitution, right at the very beginning, in fact, Article 1, Section 8. And I like to point out that it comes right after the part that calls for the creation of the post office, and right before the part that calls for what was then the Department of War. So if you think about it, the founders really did elevate the whole notion of copyright to an early spot for them. And for them it was probably not unrelated to the idea of a new country, one that was doing a lot of pioneering in all kinds of ways. And so the wording in the Constitution is to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And these days people are fond of reading from the Constitution and quoting from the Constitution. That's my probably second favorite line in the Constitution. The other one, of course, would be the First Amendment. But it's critical because it's the starting point for all the copyright legislation that has followed since. And for people who may want to know a bit about it, copyright is one form of intellectual property. And I'll very briefly tell you about some of the others. There are trademarks, which is a distinctive mark or symbol or logo, the swoosh symbol, a mark on a kind of silverware or china or that sort of thing. And it's a species of consumer protection law as opposed to a kind of property law. It's just a way of helping people know that the product that they're buying is actually what they thought it was. There's a trade secret, which is a formula, a process or a design that lasts as long as it remains a secret. So the formula for Coca-Cola or the recipe for Kentucky Fried Chicken, for example, are trade secrets. And then there are patents, which protect inventions that are useful, novel, and not obvious. So you can't invent the paperclip and try to get a patent for it, because that's rather, not only has it been done, but it's rather obvious as well. So for patents, they have to fit all three of those designations: useful, novel, and obvious. So there they are again. If you have any questions about any of that, we have a lot of information on our website that goes into those various aspects of intellectual property. It's critical to note that copyright law in the United States protects authors of original works of authorship. And I was just emphasizing the point about patents, that they had to be novel, had to be something new, something really important. In the case of copyrighted works, the emphasis here is on original. It doesn't have to be good necessarily. It just has to be original to you, and that is protected. Copyright today protects both published and unpublished works. So for example, if I take that picture with my iPhone, even if I haven't posted it yet to any Facebook page or printed it out and tried to sell it outside in Times Square, I still have the copyright on that. As long as it is in a fixed and tangible form, you are the copyright holder. We'll get into more of the details on this, but it does not require any registration any longer. And what copyright does, what the law does to protect you as the copyright creator, is to give you exclusive rights for the use of that material. Now, of course, for freelance writers, it's important to understand what happens when they are writing an article, or for that matter, writing a book. The copyright is initially yours, but you may enter into a contractual relationship as a freelancer, and this is more common than it ever has been in the past, so-called work-for-hire contracts, in which you will be asked to transfer the copyright to the publisher. Those are contracts that, as I say, are becoming more common. You should look at them very closely. If you have any questions about them, it's well worth, I'm sure, asking somebody here at ASJA. I certainly, again, welcome questions like that at copyright.com. And if you are an employee of a newspaper or any kind of publishing entity, the New York Times or the Boston Globe, it's pretty much standard that they are the owners of all the work that you create. So if I create this PowerPoint slide deck for Copyright Clearance Center, in fact, the copyright is for Copyright Clearance Center. It is not for Chris Kenneally. And the rights to any piece of copyright can be transferred in whole or in part. And it's also important to recognize as a writer, if you are publishing a book, if you're self-publishing a book, and you include photography, or you have a piece of artwork as part of the book jacket and so forth, you may have the copyright to the collected book, to the work itself, but there would be individual copyrights that adhere to the photography, to the artwork, and so forth. So you really need to pay attention to all those sort of various slices of copyright that occur. Copyright these days lasts quite a long time. When the Constitution was written, the period was for 14 years, renewable for another 14 years. Today, any work created, piece of music, sculpture, printed word, is protected until 70 years after the author's death. So one can imagine, a young rock musician today creating music that the copyright protection on that will last well into the very next century. Now this has been a point of contention. You may be familiar with the so-called Mickey Mouse extension. There was at one point about 15 years ago, the period was life plus 50. And there were some works, it wasn't exclusively this, but this is what got the most attention. There were some works of the very early days from Walt Disney that were about to fall into the public domain, and other works like that as well. But those copyright holders lobbied Congress and were able to get past this extension to life plus 70. The point there, as the courts have found over and over, is that Congress has a right to designate what the term limited means in practice. So if you look back to the Constitution, it talks about to a limited time. You can be limited to 7 days or 70 years, but that is indeed, as far as the Constitution goes, a limited period. The works for hire, anonymous or pseudonymous works, are protected for 99 years from publication or 120 years from creation, whichever is less. I've been referring to some of these points here, but what is protected by copyright? Again, what is not protected is works that are not fixed. So, if I'm speaking now to this audience, and there is a recording of it, there is a fixed copy. It's fixed in digital form. The copyright holder, I would presume, is the American Society of Journalists and Authors for the video portion of this program. However, if I'm talking to friends and tell a story about something that happened to me when I was a kid, that's not copyrighted because it's not fixed. Unless somebody happened to be recording it with a video, or unless later I wrote it down, it must be in a fixed form. So just casual remarks, some impromptu dance, or even a jazz jam session that is not recorded is not copyrighted. Titles, names, slogans. Copyright Clearance Center gets a lot of inquiries. We get a lot of inquiries from people who want to copyright the name of their band. That's not copyrightable. It could be trademarked, but it is not copyrightable. Ideas, facts, and data are not copyrighted as well. A lot of people get concerned about this. I know we'll be talking more about permissions, But you know, a recitation of the temperature in Times Square over the course of 2011 is not a copyrightable work. It is simply a list of facts. List of contents or ingredients, likewise not copyrightable. You know, the basics of ingredients for chocolate chip cookies or something like that could not be copyrighted. But if you're a cookbook author and you have some special variations on that, or you are publishing the book with, you know, lavish illustrations and text that goes into the history of the chocolate chip cookie, all of those things, of course, would be copyrighted. And then there's the whole category of public domain, which I'll speak about in a moment. The works that can be protected by copyright and are written works, images, sound recordings, software, which you're all familiar with, of course, because every time you open some new software, or even when you download it online, you have to sort of agree to a license to that, all of which is because the software itself has been copyrighted. Motion picture, films, music, sculpture, and dance. Now, I mentioned about, you know, the point of being fixed. That's an essential aspect of copyright. You know, if you were to, you know, do an impromptu dance, you know, even in a public display, and it was not recorded, that would not be copyrighted. But if you're the George Balanchine estate, where he wrote out exactly how all of his ballets were to be choreographed, you become very litigious indeed. And anyone who wants to perform a Balanchine choreography must go to the Balanchine Foundation for permission to use it. Now, I mentioned the public domain, and the important point here is just because a work is in the public view does not put it in the public domain. This refers to a work that is no longer or never was protected by copyright. And there are some works that are automatically in the public domain from their creation, and that would be works produced by the United States government. So all manner of reports and white papers and data that is supplied by the government can be used, and in fact increasingly is being used by journalists who get access to these databases and then, you know, search through them in order to discover what might not be obvious at first, but might be a pattern in terms of prevalence of disease or the use of certain kinds of drugs, or it doesn't really matter, anything like that. All those databases are open for public search, and they are part of the public domain. Now, works that have fallen, as I like to say, fallen into the public domain are works that were published before 1923, some works that were published between 1923 and 1963 when the registration was not renewed. Now, there's a complicating factor. At that point, to have a copyright, you had to register the work with the Library of Congress. Oh, sorry, with the Copyright Office. And in those days, it was not that long period that I mentioned. It was a much shorter period. I believe at that point it was 28 years with a renewable second term of 28 years. So it's conceivable that a work, you know, a film created in 1930, when the registration expired in 1958, if the copyright holder did not renew at that point, that work fell into the public domain. As you can imagine, this creates a tremendous amount of confusion, and indeed gives rise to a whole area called orphan works, which may be a term some of you have heard of before. Is something that's being wrestled with in Congress and possibly in the courts as well. And an orphan work is simply a work for which the copyright holder cannot be determined. And so for us at Copyright Clearance Center, we like to say that unless something is, you know, absolutely verifiably published before 1923, there's always a question as to whether it's in copyright. Okay? Finally, here's a list of some of the works. I mentioned the exclusive rights that copyright gives to a copyright holder. It's the right to reproduce it in any form. Okay, so that could be a photocopy, it could be a PDF, not only to reproduce but also to distribute the works. And that again can be in a digital form or to distribute it on the street in Times Square or in the bookstore in Soho. It also gives you the right to create a derivative work from that, to then translate that book into another language, for example. You are the exclusive copyright holder. If someone is, let's imagine that you are a travel journalist and publish a work, even in your own blog, that discusses a trip to Central America. Somebody may think that that's of value to a Spanish-speaking audience and may decide that they'd like to translate the work on their own. They would need to come to you for permission to do that. So in the course of checking online for where your works may be appearing without your permission, which is something I recommend to any journalist in the room here, if you find it in another language, that just because it's in a different language doesn't mean you've given up the right to that. You have the right to the translation as well. The right that is also important to think about if you write fiction is the public performance of your work. So J.K. Rowling would have presumably copyright not only to the novels themselves, but to any screenplay that she may have contributed to. And then as well, this display publicly is very important. Posting online, putting material on the internet, is a form of public display. And again, a critical point, because many people do believe that if something is online, then it is free to use. But you do not lose your copyright because you put it online. You retain your rights as much as you would have in any kind of printed, tangible form. Copyright registration creates a searchable public record. That's why we think it's a good idea. It's also required to sue for infringement. It is not necessary. You still have the copyright. But again, should you find your work being used in a fashion that you believe is infringement, in order to go to court, you need to file the copyright registration form. Now you can do that at any time. So you could have a work that you wrote 2 years ago, and you find it being infringed again on some website. You did not lose the copyright because you didn't file within the first 30 days. You have to go and file the form at that point. But any damages that you may be able to win as a result of the infringement will only be from the point at which you filed the registration. Okay? And another thing that I just think is a neat thing to do is to be sure, particularly when you're doing your own work on a blog or anywhere, to include the copyright symbol. It is not a requirement. It was at one point in U.S. law. Many people believe it still is. If you don't use it, then you lose it. This is not true. But I believe that by putting the copyright symbol on your website page, you're identifying the work as copyrighted. You're basically advertising to people that I own this. And if you put your name and some way to contact you, that is probably the best medicine for preventing infringement, because people are aware that you've copyrighted the work and they know how to find you. They don't really have any excuse. I was reading the article in the ASJA newsletter regarding Creative Commons and some issues around images, a terrific article in the September issue. And one of the points the author made was the frustration people feel in trying to locate copyright holders. It's not always easy. And it surprises me how, especially online, we make it so hard for anybody to find us. This is true not only just individuals, but all kinds of websites. I can't believe sometimes how long it takes me just to find the contact information on just a typical website. So to the extent that you can make it easy to find you, I believe, as I say, that's pretty good medicine to prevent infringement. I've already referred to some of the basic exclusive rights. Copyright is not a single right. It's what we call a bundle of rights. They're just a whole bunch of pencils, I guess it is. You could think of it as holding spaghetti in your hand. It is transferable in whole or in part, and it is infinitely divisible. So there may be some rights regarding a certain kind of device that has yet to be invented that you reserve the right to. Again, an important point, we'll talk about it further, but this has occurred in some important court cases, one of which you may be familiar with, which is the so-called Ticini case. And that involved newspapers reusing material by freelancers in electronic databases, as they were called in those days, back in the early 1990s. That case wound its way through the courts, and in 2001, the Supreme Court found in favor of the freelance writers who had argued that when they gave the rights to their work to the New York Times, that was only for the print version. It was not for the electronic version, because nobody was thinking about electronic versions when they were writing the work at that point. Now, in that case of freelancers, if you have a written contract, you will be giving exclusive rights to a particular work. And any kind of exclusive rights arrangement has to be in writing. And it has to be very specific around which rights you are assigning. Any rights not mentioned are not assigned. I think that's a critical point as well. So, somebody may go on pages and pages about all the rights that if you have a book contract, you'll see that yourself around large print editions and so forth and so on and so on. It's an attempt by the publisher to enumerate as many of those rights as they think they need to acquire. But any right not included is arguably retained by the original author. Again, a point that's very critical today, because with the rise of ebooks, there's a debate out there as to whether publishers acquired those rights when they acquired the book rights, or if they did not, do they need to come back to you as the book author and try to acquire them today? So be very much aware that if you did not specifically assign the ebook rights when you signed a contract, even 25 years ago, you may still hold those rights for the ebook edition. So just a note of caution or attention on that. Now, there can be so-called non-exclusive rights, which do not require a contract, although I tend to believe in contracts. Although, as I speak at author events around the country, if I have book authors in the room, or even freelance journalists, but particularly book authors, I say, how many here have signed a book contract? And all the hands will go up. And I'll say, how many know where the contract is? And all the hands will go down. All right? People sign that contract, they get the check for the advance, and they promptly lose the contract. I would put it in a place as important to you as your last will and testament, frankly, because it will be important later on. Finally, for this section, as much as I'm giving you a kind of pro-rights holders view of the world, I think it's important to say that copyright is intended to reflect a balance. There are various parties here who have interests beyond the copyright holder. There is something called the public interest, of course, and free speech and right of access to certain kinds of information. So, try to imagine that there is an attempt to create some kind of a balance here, and that's what copyright law is intended to do. It's probably not a perfect situation. Certainly, that's how Mark Twain thought of it. He was an early advocate of copyright reform in this country, and he liked to say that whenever it's time to reform the copyright laws, that's when the idiots assemble. But he was thinking of Congress in his day, and I don't know that, again, much has changed, because he also said that Congress was the only native criminal class in the United States. We'll talk briefly about infringement. Now, infringement, as a matter of law, is the unauthorized use of copyrighted material in a manner that violates the copyright holder's exclusive rights. I earlier gave you the example of the right for translating your article into Spanish. That would be a matter of infringement for which you would be able to take someone to court, again in the United States, if you had registered the work. What you can regain as a successful litigant is monetary damages, injunctions, meaning preventing someone from continuing to publish a book or make it available in a bookstore, and there may even be criminal liabilities, although that's fairly uncommon. And the way that damages can be determined are the instances, the number of instances of infringement. So typically in copyright cases, the really big ones, the infringement is going on a continuing basis. And so these kinds of damages can add up to 6, 7 figures. And with copyright infringement cases, statutory damages apply, so they can be triple damages. So if a determination is made that your loss is $1,000 or $100,000, potentially the recovery could be 3 times that amount. Now, I mentioned about copyright being a balance, thinking of, the interest of the copyright holder and the interest of the people, as we now say, who consume the content. We used to call those those content consumers readers, but today they're consuming content of all kinds, and they have some rights as well. One of them, if you're a book author, you may be familiar with, is the so-called first sale doctrine, which is Section 109 in the copyright law. And an important point to be made here is that just because you acquire a copy of the work, it does not mean you acquire the copyright to the work. All right, so under the first sale doctrine, it allows for the sale and transfer of the physical copy of a book or a CD. And it's in part what makes possible the used book market in this country. And again, if you're like me and you're a book author, it could distress you that your book is on sale on Amazon at a certain retail price, and then also available in used form for 1/10 of that price. That feels distressing, feels like something's being lost there, but under Section 109, it is an allowable activity. And again, I would emphasize that for somebody who acquires these books, when you buy a book, it does not mean that you can then, or for that matter, let's say a CD or a DVD, it does not mean that you can then use that material in your own work. So, if you're imagining that you're creating one of those so-called enhanced books now, an e-book that would include audio and video and so forth, you would not be able to, just because you had the CD for Motown Greatest Hits, use that as the soundtrack for your book about the 1960s. I'm actually alluding there to an interesting case, if I can mention. You recall the documentary Eyes on the Prize, which was on PBS back in the early 1990s. It won a number of awards, and it was a documentary series looking at the civil rights movement. And at that time, this is pre-web, pre-DVD, pre-CD. In fact, there wasn't even much of a VHS market, I don't think, at that point. And they had acquired the rights, the public transmission rights, to a variety of Motown songs and soul tunes and so forth, because they were really the soundtrack to the civil rights movement. All well and good, until 15 years later, when they wanted to create a DVD of that work. Now, at that point, I'm sure they wanted to be compensated, but the point was simply that the documentary had become part of the National Archives. Fundamentally, it was one of the sort of essential works to look at if you were interested in the civil rights movement. So they went back to all of the music rights holders to license it for the DVD. And the works that they had acquired for not quite pennies on the dollar, but for fairly reasonable sums, the fees had gone into astronomical heights, and they weren't able to use any of those works until they finally won a grant from the MacArthur Foundation for multiple hundreds of thousands of dollars just to make the rights, just to acquire the rights to make those works available. So you want to be sure, because you don't want to have to do that looking backwards. If you create that enhanced book and you use some of those songs and it becomes successful, at that point the copyright holder kind of has you over a barrel. There's a term here called fair use, which again I'm expecting most of you have heard of, but may wonder what it's all about really. Fair use does not mean it's fair for you to use, okay? It's a limitation on the requirement that works protected by copyright cannot be used without permission. It's not a right per se, but it's a defense. So, for example, if you are charged with, let's say inadvertently, you have infringed on that copyright for the music I was describing, and the copyright holder comes to you, you could conceivably create a fair use a defense, and you may or may not win. But it is in that way that fair use is used as a defense in a copyright infringement case. And it is an attempt to balance those rights that we've been talking about. And there are 4 factors. The purpose and character of the work, is it for a financial or business benefit? And I would argue, again, that this is very critical for people in the room and online. If you're a freelance writer, if you're a professional author, and you're making your living, and as a writer, as an author, and you have a blog, which is used to build your audience, to promote your book, and so forth and so on, to perhaps preview chapters of the next book, and so forth. If you use images to illustrate that blog, you may well be making yourself liable to copyright infringement case, and you would not have the defense of fair use, because clearly that blog is a commercial work. It's used to promote your profession as a writer. So you really have to start with that, is it for any kind of commercial benefit? Is the work created or factual? And a novel tends to be less open to fair use than, say, a report on a city council hearing in New York City. This one, the third one, is the amount and substantiality of the work used is always important. I go to universities and they tell me they think that, well, if I'm only using 10% of the work, it's okay, or if I only use 500 words. But that 10% or those 500 words could be the heart of the work, could be the most important piece of the work, and by using them without compensation, you're diminishing the commercial potential for the sale of that book. So there is no secret formula to how many words that you can use. And finally, it really all does come down to, is there a loss that the copyright holder suffers? All of these things are the tests that a judge will put the case to, and each case is different. So there is no way to say, well, in this previous case, The Nation won or lost, a very famous case about using an excerpt from Gerald Ford's autobiography, a very short excerpt. I mean, I'm not sure I should dare to ask this question, but how many people even remember who Gerald Ford was? Well, I do, but I mean, it's a diminishing group of people. And how many people even remember what it was that he did besides whack a golf ball once in a while? He pardoned Richard Nixon. And in his autobiography, that was the only reason anybody bothered to read it, was to find out why did he choose to pardon Nixon. And The Nation obtained an early copy of his autobiography and published that section as part of a commentary. And they had said that this was fair use, and they used various arguments that I described. However, they lost. So it is, but that doesn't mean that another case very similar couldn't come into the courts today and be found by a judge in an entirely different way. So there are no guarantees around it, but it does mean you do have some rights, particularly in the academic sphere, particularly around research and so forth. I would say again, the less commercial the use is, the more likely you have the right to fair use. So just to review those points, so physical ownership doesn't mean you have the copyright. Attribution, if you say, well, I got this from Alex Owens, and go to her if you want more, that's not good enough. That's not a substitute for permission. Public domain doesn't mean publicly available. And copyright, by the way, applies to print and digital works. I think it's important to mention about international law, and I'm kind of giving you guys Copyright 101 stuffed into, 10 pounds of copyright stuffed into a 5-pound bag. But I hope it's helpful, and it is going to be recorded so you can kind of go back and review all of this. But a lot of people do come up to me again and talk about something called international copyright law. There is no such thing as international copyright law. Every nation has its own copyright laws, and national treatment always applies. There is only one significant international treaty around copyright, which is the so-called Berne Convention. Other than that, copyright law is different in every country. So, for example, Google was sued not only in the United States, was also sued in France. In the French courts, they lost. In the American courts, well, it's still going on. No one knows where that case is going to wind up. But just because they lost the case in the French courts, it does not mean that they will win or lose in this country. Now, I mentioned Berne, and just briefly to say, you know, territoriality, national treatment, and minimum protection. That's all that the Berne Convention provides for. If you're in the U.S., U.S. copyright law applies. And you will find, and so this is true with, I mentioned the Authors Coalition and some of the work that we do around the world, various countries, in Europe particularly, have so-called statutory licensing. And what that means is that in the universities, even in some cases in the corporate world, people are free to use copyrighted materials of all kinds. Essentially, they pay for it in the form of some kind of a tax or a fee. Sometimes that fee is attached to the price of a DVD, blank DVD. Sometimes it's attached to the price of a photocopying machine or a printer. But you know, one does not have to get permission. In this country, permission is always required. You must always seek it. So I kind of got to that slide here. This is the prison of PowerPoint. Sometimes you say things before the slide comes up, and I guess you know, the notion of permission, which is something that Copyright Clearance Center is about, goes into, you know, creating and distributing, displaying digital copies, storing in a database or on an intranet, and frankly, as I said at the start, because everything we do today is a form of digital fixing of something, an image, some words, and so forth. Every time you go to use any of that, unless it's your own, it's conceivable that it's necessary to get permission to reuse it. Because I do want to give as much time as possible to questions in the audience, I'll move briefly through some things that I think are important to mention. Sharing is easier than ever. Everything we do today is around this notion of sharing. I like to highlight, you know, P2P, peer-to-peer. Peer-to-peer is not necessarily illegal at all. It's the ways it's used and the works that are being shared that potentially are cause for infringement. None of these things are illegal activities, and I don't mean to imply that they are, but they are so common, and then they are so common in our personal lives. When we move over into our professional lives and we start to use these same activities, we're doing some things that in the personal sphere is reasonably acceptable. You know, your sister sends you a photograph of her child's birthday party, and you flip that over to a friend, or you put it on a Facebook page. You know, conceivably she has copyright to that. It's not likely, unless your sister has it in for you, that you're going to wind up in a court case. But in the workplace, as a journalist, as a writer, if you have been working with a photographer who, you know, accompanied you on some travels around the Soviet Union, the former Soviet Union, and you published those photographs, even in a self-published work, and you didn't get the permission of the photographer, again, that would be cause for an infringement case. The thing I'll say about digital content, any non-digital content that is protected by copyright is also protected in a digital form. I think it's worth saying because this is the essence of the Google book case. What Google did was to go into the libraries of the University of Michigan and Harvard University and all these libraries around the world and take all those copyrighted works in print to create a digital version of them. Now they have their own argument, and I'll let Google present their own argument, but in this particular case, just because it's a digital form doesn't mean that the copyright that was in the original print work isn't part of that digital form as well. I love this sort of thing. I mean, you know, you probably are aware of this again if you're in journalism today. You publish something today and it goes around the world in all kinds of ways, Facebook and Twitter and so forth, and the expectation of the content consumer today is to get that work pushed to them. And again, all these practices are creating an atmosphere where the notion of copyright and the value of copyright starts to kind of lose ground. And so I guess we're all here to understand it and perhaps defend copyright. This is actually part of copyright law. People occasionally make fun of it, but it's an important one. Copyright law protects works that, in all kinds of forms, now known or later developed in this or any other universe, I think, at one point in some contract. But that's an important point because, I have to remind you that it's only been since April of last year that the iPad was commercially available. It's only about a year and a half, 18 months. 2 years ago, it was just a gleam in Steve Jobs' eye. And today it's not quite taking over the world, but it's certainly very prevalent and definitely determining how authors and publishers are thinking about their published works. It's less than 2 years' time. Who knows what's going to be available in 2 years' time from today. So, I was intrigued with the article. I do recommend it to you in the September issue of your ASJA newsletter around images. What should be said about images? Facebook is now the world's greatest repository of photography ever conceived. I mean, I may have a number here, but it is the billions. It's in the billions and billions of images. Many people today, because of the way that photography seems to be like grains of sand on the beach, that therefore the works don't have any kind of commercial value anymore. You try to say that to a meeting of the Society of Media Photographers or the Editorial Photographers Association, they'll definitely argue with you. I think I've made my point about blogs. Your blog is copyrighted, but also if you're reusing work in your blog, you need to be aware of the need for permission. Video too, of course, is becoming so prevalent. Great statistic. 20 hours of video is posted to YouTube every minute. Again, that sounds like not much. I think probably the last time somebody looked it was 20 hours. Perhaps now it's 200 hours. Certainly, if I were to now go and show you one of those videos, I would be publicly displaying that video. There's a copyright permission question there as well. Again, in the case of your blog, in the case of an enhanced book, the reuse of a video online in that work could potentially make you liable to copyright infringement. And you wouldn't even know. Somebody could say, well, I have the copyright to that work. Sometimes they do and sometimes they don't. You see lots of stuff. I mean, we all love going on YouTube to find old clips from old movies, but that doesn't necessarily mean that MGM or United Artists or anybody else is given permission for those works, and that's what keeps a lot of people at YouTube busy, which is responding to all those takedown notices that they get on a daily basis. Podcasts are also available. Small plug for the one that Alex mentioned, Beyond the Book. Again, often freely available in transcript form as well as the audio line, but that doesn't mean that you can use it freely. I'm sure the gents in the back know about this. Music is readily available, and the latest figure we have is that 95% of downloaded songs last year were not paid for. They were infringement cases. So all of this is happening in a situation where you, the creators of text, begin to worry about things. Again, the revenue for the newspaper business is going down, but the readership is growing by leaps and bounds. All of these websites that the various newspapers have more readers than ever. The Boston Globe, the Guardian, you name the newspaper, they all have more readers than ever. What they are struggling with is the so-called business model around online content. But if you, probably the most common form of sharing an article, you share this with a friend, there'll often be limitations. When you use one of these services in the New York Times or any of those sites, you in fact are taking out a license to reuse that work, and it does limit you in the ways that you can use that. So you can't just immediately start to take copy from the latest article about Iran and put it into your blog. So there's a bit of summary. Copyright protects digital and non-digital, and I'm going to tell you briefly about ways to get permission. If you are dealing with text, the best place to start is with the author, the creator. In some cases that is the individual. Other cases, it could be a publisher. If you're not willing, or if you've got a budget that allows you to hire somebody to do this for you, there are a number of freelance permission services online that will take up this job. Copyright.com, which is our website, lists, as I mentioned, multiple millions of works, and for various reuses of all kinds. You can go and search in our database for the work as well. So there are options available to you. In the case of something beyond text, images, music, and film, there are a variety of these so-called collective management organizations, ASCAP, BMI, various stock photo agencies, Corbis, ASMP, which is, again, a colleague organization of the ASJA. They have their own licensing services for photography. So there are places you can go. If you're frustrated and just don't know where to start, start at copyright.com. We respond to every request we get. We don't always guarantee, well, we don't guarantee that we can get you permission. But even if the work is not in our database, we will make an effort to find the copyright holder. And if you wish to license your work with us or learn more about all these points that I've made, you can go online at rightscentral.copyright.com. There are some licensing agreements there for your works with us. There's no fee to license your works with us, and it's all explained there online. So for more on what we do for you as an author, it's rightcentral.copyright.com. Well, that gives me a moment to pause. So far, the sirens have kept quiet. We haven't been raided yet, which is a relief. And I hope we have had some questions online, and I hope you have some questions here. But I thank you for the opportunity to discuss all of this with you.
I hope you'll forgive the microphone. It's for the people at home.
Hi, I'm Michael Sherry. I'm a freelance writer. I write for the Financial Times and Barron's and some other publications. And it just dawned on me that I might be breaking a law, and I wanted to ask just how common this is. But I've got my own website. I'm self-employed, so now and then I'm really proud of an article. I clip it, scan it, put it on my website. Friends of mine look at it and say, "Yeah, great." How many laws am I breaking when I do this, and what sort of damages am I liable for?
Well, in principle, you would require permission for that, unless, and I don't know what the contract is, what the arrangement is that you have with those publications. And even within publications, it depends on the editor you're working for. So it's very hard to answer that question categorically. You are on safer ground if you link to the article online. So far, no one has been found to be infringing if they use a link. But, creating that PDF, and the point about that is, and this is the secret of the internet, it's a copying machine. It's a worldwide copying machine. I mean, the photocopier was what brought Copyright Clearance Center into existence in 1978. That was the disruptive technology of its day, because suddenly there's this term out there called digital rights management. You probably heard of it, right? Well, rights management in those days it was awful darn hard to copy anything. If you wanted to copy a book, you had to go buy a printing press. Then the photocopier, and that's what happened. Dickens would be published in London. Somebody would take a copy back home to the U.S. They would give it to a printing press, and the printing press would then just go about resetting the entire book. And when Dickens came to this country on one of his famous reading tours in the middle of the 19th century, he was horrified to find copies of his work available by all these various publishers, none of whom he had seen a dime from. So to answer your question, you'd probably want to find out from your editors as to what you may or may not be able to do. They may be quite proud to have you as a writer, and they may not find a problem with it. But I think the safest place to start is with the link.
I'm going to ask a tiny follow-up.
Sure.
I was just going to say, my editors say, yeah, great, we'd love the attention. but they're not the boss ultimately.
right.
And I don't
They're
really
not
know
the
what's
lawyers, are they? No.
I mean, I've gotten multiple copies of contracts from the Financial Times. They've sent me 3 separate contracts. I've only signed 1, and they keep badgering me to sign new ones. And there's slight nuances and changes. I don't know what it costs to show this to a copyright lawyer and have them analyze the difference, but I imagine I'd lose money on it thinking of what I get paid to write these articles. But ultimately, I don't think it's my editor or editors who are going to be the ones to say, you know what, we've got to make an example of this guy. It's going to be someone above them.
Hard to answer that one, but I'm thinking of the advice my old Irish grandmother used to give me, right? Whatever you say nothing.
Is there anybody back here?
Hi, Tim Harper. Thanks for coming. This has been really instructive. Many of us publish our stories. We find them picked up, stolen. We go after it. And one of the things I've had with great success is saying, is there's statutory damages involved in this. And I'm not really up on what the statutory damages are now. Am I making an idle threat, or I've registered?
If
I've
you've
my
registered,
copyrights.
then as I mentioned, you would certainly be able to recoup those in court, or you would be potentially able to recoup those, right? The determination of the damages is made by the judge based upon the arguments presented.
Well, what's statutory damages? And that doesn't depend
means
on out-of-pocket.
That means triple. I probably shouldn't go into the details. I'm not an attorney, but what I do understand about statutory damages is that you are able to claim them, and they would be triple the value of or the lost value to you.
I think I am an attorney. I think that's not quite right. I think there
Okay.
are some. There's a 20,000 threshold, I think, for some things. It's changed recently, and I wasn't sure if you.
You know,
knew
in
what
that
it
case, then
was.
I would be delighted to
Yeah.
go back to the office and try to get you a clearer
Okay,
answer
great.
about that.
If I could ask another question, what do you know about the hot news doctrine these days in terms of fair use? This is.
I'm familiar with it. I mean, you know, hot news. I remember actually it was a case related to this fair city here when Elliot Spitzer got caught. Very hot news. I was going to say he got caught with his pants down, but that just probably is more than we want to go into. The New York Times was able to determine the woman involved. Went onto the internet, found a photo on her MySpace page, and published it. And as I looked at it right away, and that was within hours of the news breaking, they had determined who this was. And I thought, my goodness, the photographer might go after them. But in that case, they would certainly be relying upon that, I would imagine. Wouldn't you say?
No, I would. That's well. Yes, I would agree with you.
Okay. Well, but I'm open to what would be the exception, or how would you see
Well,
that?
I think what the hot news doctrine applied to was primarily in terms of fair use with, like, financial news, for example. If
Oh, I see. Right. Of course. Okay.
Where-
So where
where-
somebody breaks the news and then someone comes along 30 seconds later and
that's what it was about, was a matter of consolidating, aggregating somebody else's reports that they'd worked on for a long time, and then putting it out, and how much of that is, there's a, I was going to ask you if the court case has been resolved, if you know.
I'm not familiar with
Okay,
that.
thanks.
Apologize. Thank you for a great question.
I'd
though.
like to submit one question from the online audience.
Sure.
This is a very quick one. Ashley from New York asks, is it permissible to use the names of copyrighted characters as main characters in my book? My characters share no similarities with the copyrighted characters except their names.
Tim's shaking his head, and he's the lawyer in the room. I mean, again, I would imagine a litigious world, and I would be very hesitant to do that myself. I suppose.
We know there's caution against using
There's-
real people's names.
Right.
Obviously.
I mean, those. The problem there is that the name is probably trademarked rather than copyrighted. So if you really are just using the name, if you're not sort of characterizing Superman and his father from Krypton and da 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 da, Tim's nodding his head. I think I got that one right.
Is there a way to find out if a name is trademarked
Well,
before you go down that road?
Sure, if you pick up a copy of the comic book and it says TM up in the
Okay.
corner. But TM, and again, Tim helped me out here, is not even a requirement. You do not need to register it. That's when you get the R within the circle. You can have a TM, you can just slap it on there if you're claiming the trademark itself.
Yeah, we can steal characters.
Right. So the answer is yes.
And we have a question from the audience.
Okay, this is Ernest Oppenheimer. I'm a longtime member of ASJA. I have a problem with the computers. Most of us, well, I had for a long time the XP Microsoft. It came from Dell. And the XP had some. See, the problem is, as you saw in your first paragraph, you said that patents and authors, I mean, people who create patents and authors are protected by the Constitution, the original Constitution. And somehow that can lead to confusion because the two are not the same. Microsoft, for instance, tries to insinuate itself into my writing by rearranging headings or chapters which are totally absurd because they are not mine and I refuse to have anything to do with it. But in the new one, the Windows 7, they spent some 400 pages spelling out what their rights are in relation to articles, books, and so on.
Okay, I'm not really sure. I mean, I know, as I mentioned, that there are licensing agreements around the use of software. I haven't heard that Microsoft is...
I don't want to use that software.
Well, then there are open source softwares online that are alternatives, and I would just suggest if you don't want to use Microsoft, you don't have to. There are ways around that. Is there another question? online?
Yes, we have a question online from Peter Brantley of the Internet Archive. This is a pretty highfalutin question, but I'll pass it along.
Okay.
Do you believe it is in the public interest to create an extended collective licensing framework that would govern access to digital versions of out-of-print works?
Well, I first of all, Peter's a friend, so I want to say hi to Peter. I enjoy his writings. He's got a blog now for Publishers Weekly, which I recommend to people. And that's the definition of a loaded question. But I'd like to unpack it because I think it touches on a number of points that I covered here. I mean, there are some phrases Peter uses about, is it in the public interest? There's one part that you would have to look at. To create an extended collective licensing. I was telling you about statutory licensing. Extended collective licensing is a kind of statutory licensing. In other words, legislation that makes the use of copyrighted works available to people. That's the second part of it. And then this notion of digital versions of out-of-print works, that starts to veer off into that category that I was referring to called orphan works. All of these are ways of looking at this tremendous challenge, which was raised in part by the Google book case, but is coming up in so many other ways as everybody begins to look at the libraries of the world, the collections of art, sound recordings, film, all of these, treasures of our culture, and asking about how to preserve them, how to make them available. And the competing interests, how wonderful and miraculous it is that wherever we are, if we have a laptop or a phone, we can go on to, Google or some other search engine and come up with, a copy of Macbeth. I mean, when my daughter was in high school, she was writing her report on Macbeth, and I was traveling somewhere. If I had the laptop, I could look up a scene that she was looking at. I didn't have to carry the complete works of Shakespeare with me. It was there in that laptop for me because of Google or because of some other search engine. That's tremendous value in that. But there are so many competing interests. That would be a public interest. It certainly sounds like it. And then collective licensing, that would require the agreement of Congress. And again, without getting into politics, I mean, right now they can't agree on much of anything, even when to be in session, practically. So the idea of something like a collective licensing scheme getting through Congress at this particular moment seems far-fetched, even if it might be the absolute right thing to do. And then finally, this whole notion of digital versions of out-of-print works, again, I alluded to, which is that there's a copyright that adheres in the printed work and does not vanish when a digital work is created. I guess I'm for copyright. I think it's an important question, and I think Peter raises it because it's going to be something that all of us are going to be a part of in the future. When we're doing research, we're going to be having to look at all this, and we want all this work available to us. That's what we want, don't we? But do we want to come to some kind of terms with how we compensate people for that, how we make it available, what the terms are? Are we really going to can we imagine a time when we're all going to agree on that? I think that's a very difficult question. So I hope I answered that on my behalf, not on the behalf of Copyright Clearance Center, but I thank Peter for the question.
Hi, I have two questions. I'm Suzanne Curry. I'm here as a guest.
Hi, Suzanne.
Can you copyright the order of play of music that has been copyrighted and contains also pieces that are in the public domain?
I'm not sure I entirely... Can you give me an example of what
Sure. My husband does an annual concert, and he does a bunch of music that some is copyrighted and some is in the public domain. Can the order of play be copyrighted so that he can own that order of play?
As a sequence or a playlist almost.
Yeah.
That's a new question to me, but Tim's smiling. He's waiting for my answer. I can't. As
the list itself, if it was printed out and fixed, could be copyrighted, but he can't keep anybody else from playing things in the same way that he did. Does that make sense?
No, but
makes
in the
perfect sense.
same order that he did?
He can't say you can't play it in the same order that I did.
But if the concert is titled, like in this case, it's called The Pipes of Christmas, and it's all Christmas music that's done in bagpipe.
Yeah, I would be
Can
very
that order of
reluctant
play
to say that
be
The list
right.
copyrighted?
The program, exactly, Tim.
but not the actual order of play.
Exactly. I mean, the whole program, and perhaps he includes an essay describing why that particular work precedes this one because the earlier work is in the public domain, is from an old Scottish hymn, and then somebody came along 20 years ago and did a version of it or something like that. All of that would be entirely copyrightable. But if he walked in on a performance that had the same order of work, I can't imagine he would have any action at all. And Tim's agreeing with me.
And the other question I have is, I'm just starting to write a book, and can a website or domain name created for an original work offer any protection of copyright?
Well, you can copyright online materials. That's what you would need to do. But the website itself, I'm not sure, again, what the question is. I mean, you get the rights to a URL. So, for example, if the book is The Great Gatsby,
Right.
you would go and you could register thegreatgatsby.com. And you would have the right to that URL, absolutely.
But you're saying you'd have to register it with a copyright office?
No, you go to whatever is one of the domain registries.
Oh,
and
okay.
and do. I mean, I have to say, I had a couple of books on the history of Massachusetts, and one publisher, I sat down with him, and he said, I want to call it Massachusetts 101. What do you think I did that afternoon? I went online and I registered Massachusetts101.com and mass101.com. You got to do it. But that's not copyright. That's just a matter of ownership of the domain. That becomes itself very tricky, and I don't want to go down that road, but certain businesses have been able to regain domain names that have been registered by others. So I believe that organization is called ICANN, and they're the ones, it's a global organization, but based in the U.S., that governs all of that. But I'd start by registering the domain name. A very important thing to do in this day and age.
Thank you.
Sure, thank you.
Question?
Hello, my name is Stuart Bernstein. I'm a literary agent, and I'm just wondering whether you're familiar with a series of publications called the Code of Best Practices for Fair Use, which are related to a new book called Reclaiming Fair Use by
I'm
Pat
aware of that
Alfahide
project,
and
absolutely,
and
yeah.
a co-writer. And they seem to me to be filled with a whole lot of wishful thinking and misinformation about...
Your words, not mine.
Well, I was just curious whether the Copyright Clearance Center had a position on those kinds of publications.
Well, we
Because-
wouldn't have a position on them, but well, as I mentioned to you, fair use is a defense, not a right. I think from what I have seen about those particular publications, they see it the other way. They see it as a right. I'm sympathetic to the position in some parts. As I mentioned, the case of Eyes on the Prize, I can imagine it must be daunting for a documentary filmmaker to think about all the rights clearances that they would need to go through. And the more politicized among them would probably, as you say, be forgiven for a bout of wishful thinking and composing what they think should be the law of the land. But they're not Congress. And God help them if they try to imagine that they're judges and juries in those cases. So I would agree with you 100%. But we do not have a position. Copyright Clearance Center does not have a position because, as we say, fair use is an individual matter. Each instance is different. But the four factors don't change. So if you look at the four factors, you are able to say to yourself, with a clear conscience, and if somebody comes along and charges you with infringement, you say, well, I thought about this, and here are my answers.
I have another question. This one comes from ASJA's Vice President, Minda Zetlin, and I have another question from the
And-
President, but that's a bigger question.
Okay, and hi to Minda.
Minda says, let's pretend this is a hypothetical. I have a client who
A
insists...
pretend hypothetical.
Yes.
As opposed to a real hypothetical.
Let's pretend this is hypothetical. I have a client who insists that I use images from other websites without permission. I'm part of a team of many writers required to do this. I've objected. They claim, no complaints so far, so it must be okay. I understand their risks, but what are mine?
That's like your employer saying to you, listen, I know the speed limit is 55, but you've got to be at work at 9 o'clock, so if you have to drive 75, that's fine with me. Well, what happens when the cop pulls you over? I think that's your question, right? In that particular case, it's you doing the driving. I can't imagine a responsible publisher or any kind of media party insisting on such a thing. So
Wouldn't the answer hinge on who owns the... Is it a work for hire? Is she the author of the piece?
I think that's absolutely fair to say. Sure, yeah.
And if it's
But
not...
it's not clear from that question
Right.
as to whether they
So
are
if
or
it's not a work for hire, she's at risk of plain
Well,
old violation. Right?
I'm looking at Tim again because it would depend on the.
You're right. I think you're
Yeah,
right.
I would say you are too, and I would also say that the contract that the person's working under, because there are works for hire, and there are, I know in some of the things that I have signed, there are, I forget the exact term of art, but it's a kind of indemnity clause that says, I attest this is an original work, that it is mine, that it hasn't been published previously, blah, 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 blah. If those kinds of clauses are part of the contract, and yet the publisher is insisting on using work that is not original,
Well,
that
we
is
have
not...
to assume Minda
uh,
would not
You know,
go
it's-
that road.
It's more of an ethical question for Minda, because she can do this, but it's on them. It's not on her.
Right.
if it's a work for hire.
Right.
But if it's not a work for hire, it's on her.
But I would say this about that: that the notion is, even though it sort of strikes one as a bit bizarre, I think we can imagine it coming to that, right? I think that the respect for copyright has become so diminished over time. The business of publishing has become so strained over time that just get it done becomes the principle, I think, and get it done as cheaply as possible. But here's what I would say, and again, it's mentioned in the article in the ASJA, but there are books out there. we had a question about fair use, but there are books out there that can direct you to all kinds of websites where there are images available for free use. You know, Creative Commons has made that possible. Many university libraries make that possible, their own images and so forth. So, you know, if that publisher really wants to save some money, there are ways to do it without forcing poor Minda to break the law.
Okay, and from Sally Shannon. She says hi and thank you.
Thank you.
She says she's been asked by members whether, with study and tutoring, they might manage filing under Section 203, the termination clause. Can you talk a little bit about that 5-year window and whether you think a well-informed writer would still need legal counsel?
Not with Tim in the room am I going to talk about that. Yeah, I mean...
You don't know what she's talking
that's
about?
That's the claim. There was an article worth reading if you haven't seen it around one of the performers, I guess you would say, in the Village People, who claims that he has copyright in some of those songs, and you know, I'm stumbling to get the exact facts right, but there's a 35-year window which has appeared in which the reversion from the recording right can go back to the original artist rather than be held by the recording publisher. But it is a convoluted set of laws, and right now it's almost in the same space, I would say, where ebooks are. You know, eventually there's going to be a case, and that's going to determine the future of that. You know, in the case of, and we have an agent in the room, and I wonder if he has any opinion on this. You know, some publishers claim that the right to publish a book means to publish it in absolutely any form whatsoever. They don't need to go back to you and get the electronic rights to the book. That's the position of some major publishers. He's nodding his head. Well, right. But increasingly important as the importance of ebooks rises in the publishing business. And of course the position of authors and their agents is that no, you have to come to me and get permission for those rights. Eventually someone's going to be made an experiment of in court. We haven't come to that yet.
Are there any more questions from the room? Oh.
I was just wondering how one goes about quantifying, you know, financial damages from copyright infringement.
It would be a complex matter around, you know, in particular, like, for example, some of the cases that I'm familiar with the Copyright Clearance Center, because we work predominantly in the corporate world, you know, there are subscription newsletters, which, you know, the subscription can be in the multiple thousands of dollars per seat, if you will. And there's one case, the Legg Mason case, it's called. Financial institution was reusing financial, you know, newsletter material and sending it out to the various offices around the country. And by the time the judge was finished adding up the infringement and the damages, it came to something like $17 million. So it can add up pretty fast, but that was that particular case. There is no way to say, you know, the use of this amount of work is going to, you know, this much pound of content is going to turn into this particular dollar figure.
But I mean, what's that based on? I mean, is that based on the cost of a certain number of subscriptions over a certain number of years?
I would imagine that's where that starts, absolutely.
It's too much money. I mean, millions of dollars.
You could argue that.
I'm sure someone did.
I'm sure someone did, absolutely. Well, I appreciate your questions. I hope you appreciate my effort to be candid and to be as complete as I can be. And if I haven't answered your questions as fully as you'd like, or if there are people online who have some questions they would like to ask of me, again, my email address is chrisk@copyright.com. I want to thank Alexandra, Diana, and Lisa behind the scenes for running the gear, and to all of you in the room today. Thank you very much.
Thank you, Chris. I just wanted to say thank you all for coming. Please do grab a sandwich if you didn't get one. And I wanted to say our next event is scheduled for November 17th. We'll be hosting Yahoo's expert on search trends, how to interpret them, and the surprising things they tell us. It's actually going to be quite entertaining and useful for writers. So we look forward to seeing you then. Thank you for coming.